Attorney discipline. This unit covers attorney discipline and rules 8.3 through 8.5. 8.3 regards reporting professional misconduct. This rule requires that when a lawyer knows that another lawyer has committed a violation of the rules that, quote, raises a substantial question as to her honesty, trustworthiness, or fitness as a lawyer, close quote, he must inform the bar. Rule 8.3b provides a parallel requirement regarding judicial misbehavior. It requires that when an attorney knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office, the attorney must report this to the proper authority. The comments note self-regulation requires that members of the bar come forward to initiate disciplinary matters. Comment 3 notes that every rule violation by an attorney need not be reported, only violations that raise a substantial question as to the honesty, trustworthiness, or fitness. Substantial refers to the seriousness of the offense. Subsection C may not require that an attorney report a violation if it requires the disclosure of confidential client information. However, in many instances, the conduct can be reported without such disclosure. Also, Comment 2 states that the lawyer should encourage his client to consent to disclosure where it would not substantially prejudice the client's interests. How does the responsibility to report relate to attorney supervision and responsibility? If an associate is ordered to do something clearly unethical by a supervising partner, she not only has a duty not to do it, but she may have an obligation to report this to the bar. Subsection C provides one additional exception. It provides that a report need not be made of information gained by an attorney or judge participating in an approved lawyer assistance program. Rule 8.4, Misconduct. This rule defines what professional misconduct is. It is misconduct to violate or attempt to violate the rules of professional conduct, whether personally or through the acts of another. It is also misconduct to assist or induce another to violate the rules. However, professional misconduct goes beyond violating the rules. An attorney commits professional misconduct if she commits a criminal act that reflects adversely on her honesty, trustworthiness, or fitness as a lawyer. Comment 2 says that many kinds of criminal conduct reflect adversely on an attorney's fitness to practice law, such as offenses involving fraud or willful failure to file income tax returns, offenses involving violence, dishonesty, breach of trust, or serious interference with the administration of justice. However, according to the comment, there are other crimes that concern matters of personal morality, such as adultery, that have no specific connection to fitness to practice law. The comment also suggests that a pattern of repeated offenses, even of minor significance, can indicate indifference to legal obligations and constitute professional misconduct. Professional misconduct encompasses any conduct involving dishonesty, fraud, deceit, or misrepresentation, whether or not the conduct is criminal. Conduct that is prejudicial to the administration of justice is also professional misconduct. Comment 3 suggests that manifesting bias based on race, sex, religion, age, disability, sexual orientation, or socioeconomic status in the course of legal representation is prejudicial to the administration of justice. It is also professional misconduct to state or imply an ability to improperly influence a government agency or official. Finally, knowingly assisting a judge to violate the Code of Judicial Conduct is also professional misconduct. Comment 5 notes that lawyers holding public office assume legal responsibilities beyond those of other citizens. A lawyer's abuse of public office suggests an inability to fulfill the professional role of the lawyer. Rule 8.5, Disciplinary Authority, Choice of Law. Where may the lawyer be disciplined for misconduct? The lawyer is subject to discipline in the jurisdiction where he is admitted, no matter where the misconduct occurs. Likewise, if a lawyer from another jurisdiction provides services in our jurisdiction, he is also subject to discipline here. There can arise choice of law questions. If the conduct in question arose in a matter before a tribunal, the rules of the jurisdiction of that tribunal apply. For any other conduct, the rules of the jurisdiction where the conduct occurred apply. The only exception is if the predominant effect of the conduct is in another jurisdiction, then the rules of that jurisdiction apply. The comments explain that these provisions are designed to resolve potential conflicts at the outset, particularly given that sometimes the rules of different jurisdictions require different actions. Disciplinary process. Let us now briefly discuss the disciplinary process and machinery. This is not dealt with in the Model Rules of Professional Conduct. Rather, as with admission, state court rules set forth the procedures for discipline and the standards for what sort of sanctions are appropriate. The ABA has promulgated model rules for lawyer disciplinary enforcement that most states have relied upon in drafting their rules. Typically, a complaint will be filed by a client, lawyer, judge, or member of the public. Then bar counsel, a lawyer employed by the state bar or the appointed disciplinary agency, investigates the complaint. If the investigating attorney concludes that the charges are warranted, charges are filed, and a hearing committee of the bar will conduct a hearing. Hearing committees often include members of the public, but have a majority of attorney members. The hearing committee hears evidence, makes findings, and recommends sanctions. The recommendations are next reviewed by a state court and possibly by the state's highest court. Sanctions range from private reprimand to public reprimands to suspension to disbarment. Because disciplinary procedures are quasi-criminal in nature, courts have extended basic due process protection, such as the opportunity to confront and cross-examine and to present evidence and argument. There are critics of the disciplinary system as well. They complain about the many concerns that are never brought to the disciplinary authority, and about the few cases that are reported that result in significant sanctions. Many clients do not know of the existence of the system. Few lawyers or judges report attorneys. The complaints that clients bring, that the case took too long and cost too much, are often screened out as not involving a violation of a rule. The disciplinary agency may be too slow, while troublesome attorneys under investigation continue to commit professional misconduct with new clients. The ABA and others have conducted studies of the disciplinary system and made some improvements, but critics still suggest that a system entirely independent of the bar would be superior. According to the ABA standards for lawyer discipline and disability proceedings, the purpose of lawyer discipline is to maintain appropriate standards of professional conduct in order to protect the public and the administration of justice from lawyers who have demonstrated by their conduct that they are unable to properly discharge their professional duties. This is the conclusion of our discussion about lawyer discipline.